Cool. So your question is actually quite interesting because it raised a lot of eyebrows when it came out, and a lot of people were interested to understand how the CPA applies to lease agreements, right? And when exactly is it within one's course of business to rent out a property and when it's not? And in this particular example, the question is based around the fact that in a deceased estate, the executor, no interest, actually just wants to transfer the damn property, but can't because there's been delays. And now, wants to do something, wants to put somebody in there simply with the intention of securing the property, making sure there's no vandalism, that at least somebody's there taking care of maintaining the property. Would you say that this is within course of business in terms of the CPA?
Perfect. So generally, when we talk about the Consumer Protection Act and we deal with lease agreements in the Consumer Protection Act, we obviously maintain the position that the Consumer Protection Act, particularly Section 14, which deals with fixed-term agreements, applies to lease agreements. But there are a number of different exceptions that exist within the law, okay? Most of them are very nuanced, and generally when your attorney is looking at a particular matter, they will look at these particular nuances to see whether, in fact, the CPA doesn't apply. But they are very particular to certain transactions, for instance, transactions that are entered into between purely juristic entities, transactions that are entered into where a consumer has a particular threshold in asset value or annual turnover. These are things where the Consumer Protection Act actually has exclusions, and says that the act or a particular section won't apply to the particular act. And there is another exclusion which often gets consideration, and that is a consumer in terms of the act is someone who is using an asset, and a supplier is someone who is supplying a good or a service which is in the ordinary course of business. So the act really looks towards normal consumer transactions in the ordinary course of business within our society, and where a transaction perhaps falls outside of what would be considered a normal consumer transaction. In other words, it's not in the ordinary course of business. This is also a circumstance where perhaps the Consumer Protection Act is not going to apply to a particular transaction, even if it is for a fixed term. In terms of Section 4. Now, the question of whether that has occurred on is obviously depending on the fact and circumstance of a particular case. And this was recently, at the end of 2025, highlighted by the the Supreme Court of Appeal in the case of Els v. Venter, okay, where there were specific circumstances in that case where it was a lease agreement that had been entered into between the particular parties. However, the nature of the particular transaction was such that the landlord in circumstances was not really renting out the property for the purposes of a rental income or anything like that. They were actually in the process of immigrating or determining whether they wanted to immigrate to another country, and so let out the property that they had in order to basically put someone into the property to look after it, rather than as a commercial transaction in the ordinary course of business trying to make a profit. And in those circumstances, the Supreme Court of Appeal determined that this was something that the CPA was not applicable to, because the intention of the parties was not to make a profit. It was something else, which was not an ordinary course of business intention. And so the question today really is synonymous with those particular facts of that case. We have sellers in the circumstances. They are trying to wrap up an estate. They are the executors of the estate, and what they want to do is put tenants into the property, not in an effort to make potentially profit from that particular transaction, but to rather have someone in occupation of that or vulnerable during the course of finalization of the particular estate in the circumstances. And So they are asking, is this a circumstance where perhaps the CPA does not apply to the transaction, and therefore can they include provisions within the agreement, for instance, that they can give a 3-month notice in order for whoever they place in occupation of that particular premises to leave the premises when the estate is coming up to finalization. And so having a look at the case law, that this is a response to the one that we see in terms of the case law in the LSV Venter case. It can be interpreted as a circumstance where the parties are not necessarily trying to derive a profit. This is not the ordinary course of a business or trying to derive an income from this particular transaction. This can be interpreted as a circumstance where they're actually in the screen for a different purpose, to keep that property, someone in that property during the process of finalization of the estate. And so this may well be a transaction that falls outside of the Consumer Protection Act. One thing I would warn in the particular circumstance is, however, the reason that the LCV Venter case went the way that it did was that the intention of the parties at the time of contracting throughout the lease agreement was very well documented between the parties. There was no dispute as to why they were entering into this particular agreement. And there was no dispute between the parties that if, in that case, the parties decided that they were not going to immigrate and they were going to come back to South Africa, that the tenant would move out of the property in the circumstances and they would get out, because the home that they were living in was the family home, and the parties never really intended to remove themselves from their family home. They were obviously just seeing whether they want to immigrate. So the circumstances of our case today are similar, but not exactly the same. And so there is a level of, it might fall outside of the CPA, but if you are going to enter into a particular transaction like this, what would be very, very important is for the parties, the purchaser and the seller in the circumstances, to very, very carefully note and write down the intention of the parties entering into a lease agreement, and obviously from the tenant side to acknowledge that this is what the intention of the parties is, that they are just going to rent the property until such time as the finalization of the estate happens, and then they must leave. That would be something that would be very, very clear in terms of the lease agreement. And remember, lease agreements, although they must be temporary, don't have to be for any specific period. It can either be a specific period, which we're all used to. It's a year-long lease agreement, 2-year-long lease agreement, or it can be for a determinable period. Okay, so you can say you are able to lease this property until such time as an estate is finalized or some sort of notice is given. So in these particular circumstances, interesting. I think it is a circumstance where the CPA could arguably not apply to this particular transaction. Perfect. Thank you, Bruno. That brings us to the end of PLA for the day, and we will see you again next week. Thanks, Bruno. Bye. Perfect. You were muted.